Hello, good morning, good afternoon, good evening. I hope you're all doing well. Thank Crunchy, it's Friday. I guess if you're not in the UK, you might not know what on earth that is about, but Crunchy is a chocolate bar. I used to love a good Crunchy, but I can't have them now because they're not vegan. They need to make a vegan Crunchy. But there used to be an advert and it used to be, thank Crunchy, it's Friday. So I always used to buy myself a Crunchy on Friday. So that ad completely worked. It totally worked on me. But Friday, the prosecution has finally rested their case in the Karen Reid trial. Thank everything that is holy that is over. Oh, God. Oh, God. So we got the defence case starting today, and it is a full day, which means basically starting late and finishing by 4. So I don't consider that a full day really, but anyway, it's a full bev day. Let's put it that way. It's a full bev day because they finished very early, very, very early. Yesterday, they were planning to finish by 1:30, just having the one break and no lunch because a juror had an appointment. So it had been agreed with the court and all the things. So they finished really early because Robert Alessi was banned from talking about 2 particular topics. And that was Trooper Paul and Dr. Scotty Bello. He had 2 lines of questioning for Dr. Welcher, and we didn't really know what was going on, right? So I talked about this yesterday. We didn't really know what was going on because it was all kind of decided in sidebar, and then there was this Wadia, and she rushed them along, and then yesterday morning, before the jury came in, she allowed Alessi and Brennan to give some argument regarding how much, if any, questioning Alessi was allowed to do of Welcher regarding Trooper Paul's report and his findings from trial 1 and Dr. Scotty Bello. And she disallowed it. So I'm going to play a little bit of that, just a little bit of Alessi's argument, because I thought that Alessi made very good arguments. I can't see any legal basis, not that I'm a lawyer, I'm not a lawyer at all, but I could not see any reason why Alessi could not question Welcher on the stuff that he put in his own report. He put it in his own report. He used it, particularly Trooper Paul. He's used Trooper Paul's stuff in his report. Like, I don't care if he says, oh, we did it all independently and blah, 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 blah. He still put Trooper Paul's stuff in his report. So why could he not be questioned on the content of that report? Because some of what Welcher said disagreed with Trooper Paul. I mean, Trooper Paul was very bad in trial 1. Clearly in above over his head, didn't understand the subject matter very well. But honestly, some of Welcher's clangers, some of Welcher's testimony was worse than that of Trooper Paul. It was worse. It didn't make sense. At least Trooper Paul, tried. Might got some stuff wrong, but at least he tried. Welcher, just an arrogant ass who thought that painting a taillight with blue paint and then leaning his arm all over it is going to prove something. With all his engineering qualifications and with a reasonable degree of engineering certainty, you would think he'd be able to run some kind of proper experiment to prove how on earth John O'Keefe could have been hit by Karen Reid, sustain the injuries that he did, land up in the place that he was found. But no, none of that, nothing. Nothing. Zero. Like, all right, I understand that he's not going to stand there and let a car run into him at 24 miles per hour. No one's expecting that. But he said, oh, can't use a crash test dummy. He's the only crash test dummy in this experiment. But we can't use a crash test dummy because, well, if it doesn't work out the way that we think, then you're going to criticize me for it. Yeah, that's the point. If you can't replicate what you're saying happened, you've got to question whether it even happened at all. That's the point of experiments. That's the point. Why not use computer simulations? That would be safer. Like, surely you can use computer simulation to show how a body might move when hit at maybe certain angles. You know the weight of the vehicle, you know how fast it was going. You know all the things that you would need, you know the weather conditions, you know all the things that you would need to be able to replicate the movements of that vehicle. You know John O'Keefe's measurements and his weight and stuff. So run the computer simulation with John O'Keefe in certain positions and see what happens. But no, none of that. None of that. I mean, this day and age, you'd think computer simulations would be the way to go, but what do I know? What do I know? All right, so I'm not going to play. I can't deal with Welcher. I'm not going to play any of the cross-examination and the rebuttal that happened yesterday. I just can't. I'm tired. I'm tired. I can't deal with it. So I'm going to play a little bit of a Lessie and then jump us all the way back, all the way to the end of the day. That's what I'm going to do. Let's see who's in the house. We got Down Under with Love. We got Jennifer Arias. We got Professor in Mathematics and Science. We got Angie Baby. CW. Yeah, thank God the insufferable douchebag Welcher is gone. Yeah. I feel it. I feel exactly the same. Hello, Peter, Queen of Ravens, Lisa, Blissful, Wendy. So we got Lexi. Let's have a look. Patrice, Miss Wales, Mandy. Didn't see anything yesterday. What happened? Well, not a lot. It was only half a day. If it wasn't even that, taking out the break. More of Bev nonsense. That's what happened yesterday. Amy Lou, Navin. It was just a photograph of the odometer reading. It's not like Welcher used any analysis from Trooper Paul. Well, actually, if you look at Trooper Paul's analysis reports, they look very similar. I don't care if he says he did it independently. They look very similar. So if both of those people did the same analysis and come up with different results, surely it is fair game to cross-examine the witness on why one person got a different result than you. Not that the results were really different. It was the interpretation of it that was different. So that's a perfect cross-examination thing. And Scotty Bello, he used her autopsy report. Why could he not be questioned on the autopsy? Why? I don't understand. Well, she just wasn't taking any of Alessi's crap. Okay. Hello, Emmy. Hello, Claire. And we're down to the bottom. Okay. All right. So we're going to the beginning of the day, and then we're going to go right to the end. And Hank's big finish. We're going to play Hank's big finish right at the end. All right.
Now opening the seat.
All right. Good morning, counsel. Good morning, Ms. Reed. And all right, Mr. Lessie, I will hear you on your argument on the voir dire.
Thank you, Your Honor. I'm just loading up my computer.
No, Nathan, I'm not saying it's a problem. I'm not saying it's a problem at all. I'm saying you have the right, surely, to cross-examine the witness who has done the same analysis as someone previous, but is claiming a different interpretation of that analysis. That's the problem. The problem is that Alessi wasn't allowed to cross-examine. Doesn't matter whether he found the same results or whether he found different results. He should have been allowed to cross-examine the witness on that particular issue. And Trooper Paul's report was the basis of Welch's analysis. No one can tell me any different than that.
Your Honor, I am going to address the Trooper Paul aspect, and then I'm going to address the Dr. Scorti-Bello aspect of Dr. Welcher. With regard to Trooper Paul, I would like to draw the court's attention to the following documents for the straightforward proposition that Dr. Welcher has not only reviewed, he has not only considered, that he has adopted. I went back and looked at the documents.
He absolutely has. He adopted Trooper Paul's analysis. His interpretation could be called into question through cross-examination. I can't see a legal basis for disallowing that.
And the basis for this is as follows. Slides 22 and 23 do not just depict Trooper Joseph Paul himself. They show Trooper Paul conducting the CARS analysis on February 1st of 2022. Importantly, these slides highlight the mileage odometer of 12,665, and I respectfully request the court to anchor into that odometer reading, because I'm going to show the path that that odometer reading takes through all of the documents, but I want to emphasize the start, the genesis of the odometer reading of 12,665 miles is with Trooper Paul as he conducted the CARS analysis on February 1st. Now, here's where Dr. Welcher comes in. Dr. Welcher then uses this key data point, odometer 12,665, as the basis, the starting point for his determination of the locations and times for the events of January 29 of 2022.
Okay, Nathan, so he did not adopt Trooper Paul's analysis. Yes, he did. Yes, he did. He did the same analysis. He did the same analysis. So whether he did it on by himself, he did the same analysis. Therefore, if you're doing the same analysis and you get a different result or a different interpretation, then it's fair game for cross-examination that the previous person who did this analysis interpreted it differently. That is absolutely fair game. You just want Trooper Paul back on because he was a horrible presenter and a bonehead. No, I don't. I don't want the defense to call Trooper Paul. I think it would be just distracting. I don't want Trooper Paul back. Trooper Paul did better in some respects, as I talked about yesterday, than Welcher. At least when Trooper Paul explained the analysis, it was clearer than when Welcher did it. So, but no, I don't want Trooper Paul back. I don't think it would be much use, honestly. I don't think it would be much use. I might be wrong. Welcher did his own analysis. It doesn't matter whether Welcher ran the numbers himself. Listen to what I'm saying, Nathan. Doesn't matter if he ran the numbers himself. He still did the same analysis and came up with a different interpretation. Therefore, it should be good grounds for cross-examination. And as Alessi is saying here, the odometer reading's relevant, but he wasn't allowed to get into it at all. with the witness. They used the same inputs, that's all. Yes, they did the same analysis. All right.
Dr. Welcher uses his scenario analysis of Ms. Reed's travels, and that's detailed on slides 24, 25, 26, 27, and 28 to calculate.
I mean, this is like Judge Gull in Delphi saying there was no nexus. It's the same thing. She's just given this, no, I don't agree with you, and no explanation, no legal basis. It's exactly the same as what Judge Gull was doing.
Calculate and then deduct 36 miles from the odometer, according to Trooper Paul on February 1st of 2022, to arrive at an odometer reading of 12,629, which obviously is different from the anchor I talked about of 12,665. So the assumed odometer of 12,629, again, is based on Trooper Paul's CARS analysis in slides 22 and 23, are then used as a tether, a connection to the events recorded by the VCH in the Lexus on the following slides: 28, 29, 30, 31, 32, 33, 35, and 36. I elucidate this and I explicate the slide numbers to show how many there are in Dr. Welcher's report that are rooted in the anchor point and then the change in the deduction of the odometer. So the events memorialized by Trooper Paul on February 1st, including the odometer reading, provide the foundation for Dr. Welcher's entire analysis of the VCH events. The entire analysis of Dr. Welcher's VCH events. That is the adoption aspect of what I started with. 2 more points. In addition, Dr. Welcher testified on his voir dire that the image on the left of slide 36 from his January 30th, 2025 presentation came from a file marked carsj.pol. Now, he did contend that it wasn't the exact same image, but I want to go to this. In fact, the image on slide 36 is from the drone used by Trooper Paul, and the citation for that is page 4, item 11 of the CARS report. That's where the drones are from. Dr. Welcher didn't do any drone activity.
Welcher didn't do his own independent summation of the scene. He said, he went to 34 Fairview and stood in the road and did some laser scanning. Well, we didn't see any proof of that. We haven't seen any of that. That's not been shown at all. What was the purpose of that is unclear. But instead, he took the drone work that had been done by the Massachusetts State Police and he used that as a basis of, some of his illustrative points in his report. I mean, look, that's not a big deal. I don't have a problem with him doing that. But you can't have it both ways. You can't adopt some of the things in the Massachusetts State Police report. You can't just cherry pick. And again, it's about being able to cross-examine. That there's no legal basis for not being allowed to cross-examine on the stuff in your own report. The choices that you've made, what to include and what not to include from the Massachusetts State Police reports. Why have you chosen that to report and why have you not chosen that? It's not rocket science at all.
He took the drone that he had in his report that was just a little bit different than the one I was showing him. It comes from page 4, item 11 of the CARS report. And I quote, "The crash scene was documented during the on-scene investigation by utilizing Alicia's GNSS GPS mapping system and a DJI Mavic 2 UAS. This data was input to a computer-aided diagram program, which is IMS 360, here's the key, to produce a scale diagram of this collision. So the DJI Mavic is the CARS team drone. This image of Dr. Welcher..."
So this is plagiarism. This is literal plagiarism. This is passing off the drone work done by the Massachusetts State Police as his own work. That's plagiarism.
Welcher's slide 36 is clearly and indisputably from the drone. And the only drone extant is the drone of Trooper Paul and the CARS team. Last point with regard to the Trooper Paul basis in adoption of Dr. Welcher. Mr. Brennan asked Dr. Welcher on voir dire if the image from slide 36 actually came from the CERT team, which is simply not true. The CERT team, actually Lieutenant Tully with the CERT team, took about a dozen photos of the taillight in the snow in the dark around 6 p.m. on January 29, 2022. Lieutenant O'Hara said that the CERT team never traveled back to the scene again. So there were very obviously no photos or images taken by the CERT team in the daylight from the drone. And I again refer to slides 22 and slides 23, where...
Well, it doesn't matter whether the drone work was done by the CERT team or whether it was done by Trooper Paul. Quite frankly, they're all Massachusetts State Police. My problem is that he adopted that, Welcher adopted that as his own work, which is clearly not true.
Dr. Welcher said it was... And
from a company that's paid almost $400,000. Hank Brennan has been handed a blank check, you know, get a conviction at all costs. That's what Hank Brennan has been brought in for, and that's what he's done.
More likely than not that it was Trooper Paul in those slides, but the point, whether it's Trooper Paul or not, is completely overwhelmed by what I just argued and presented as specific factual basis for a review, a consideration, and an adoption of the work of Trooper Paul. Unless Your Honor has any questions, I would now move on to Dr. Scorty-Bello. Thank you. Dr. Scorty-Bello will be much shorter. Mr. Woke, do we have the slide of the Dr. Scorty-Bello it's at the end of the slide presentation with her name on it?
The TV's off,
Oh.
but I have
You just give the slide number, please.
131.
So it is slide 131. I almost know it verbatim, Your Honor, so I will continue. If Ms. Gilman has slide or someone could turn it on. Okay, thank you. Thank you, Your Honor. So with regard to slide 31, at the very top, and this again is a slide presentation of Dr. Welcher. So up at the very top, and so Dr. Welcher admitted that he not only reviewed the autopsy report, he admitted that he not only considered the autopsy report, he admitted that he adopted it, and I'm going to put adopt in quotes, to the extent that he used it in his slide presentation, and he actually, to show the depth of those three verbs, he's got in orange highlight under final diagnosis, multiple skull fractures, base of skull, and cavallarium. He testified, obviously, about the rear wounds of Mr. O'Keefe. He testified about how he believed those wounds came about, and he cited as corroboration the highlight of multiple skull fractures, base of skull, and cavallarium. It couldn't be any more obvious, his rooting in this document and reliance upon it. Why else would he have it in his slide presentation? And he's got the name of Dr. Scorty-Bello. And frankly, Your Honor, he didn't fight that whatsoever in the questioning of him.
I mean, look, I don't see why he couldn't put stuff from the autopsy in his report. I don't have a problem with that at all. The fact that he's included some stuff from the autopsy report, because Dr. Scorty-Bello did the autopsy like no one else did. So using the autopsy findings in his report, that's fine. But why can he not be questioned on it? You know, I don't understand. I do not understand why Alessi was not allowed to ask him any questions about John O'Keefe's injuries based on Dr. Scordy Bellows' report. I don't get it.
Then you go to underneath cause of death, blood impact, injuries of head, and hypothermia. He essentially repeated that on his testimony. And then if we could, Mr. Wilk, just go to the right.
I think there was no legal basis. I think Judge Bev just wanted this done. She wanted it done today, or, yesterday. She wanted Alessi to finish his cross-examination as soon as possible, and that was her way to enable him to do so. To cut out, to probably, I would imagine the Trooper Paul stuff would have been longer, like more questions, than the Scordy Bellow stuff. But it's just a way that she thought, oh, well, he'll get it done much quicker. We can all go home much sooner if I stop him doing this. Yeah, maybe she was as sick of Welcher as we were. Yeah, there could be that too, yeah.
And so you've got highlighted head, skull fracture radiating from the right occipital skull and into the right parietal bone, right and left occipital foci, and bilateral anterior foci and orbital plates. Again, the highlighted means something. He's adopting it. And lastly, that the depiction of the skull here, I believe that's Dr. Welcher's handwriting. I believe that's his green.
No, it's not. It's not. He's wrong there. It's not. I'll show you. I'll prove to you. It's definitely from. It's definitely from. So we got the head doctor. All right. This is a live stream that I did at the weekend, or last week, and I reviewed oh no, that was the cross-examination. That's the wrong one. That's the wrong one. So this one.
I can't say what type of force or how much.
Here it is. That is from Scordy Bellows' report, like the autopsy report. The L and the R are on there. They're just cut off. There's the L. But that is definitely from Dr. Scordy Bellows' autopsy report. There's the L and the R. So no, Welcher hadn't put those on. This is straight from the autopsy report, straight from it. And this was actually shown in trial 1. I'm playing this from trial 1. Like this is the live stream I did reviewing Dr. Stonebridge, who hasn't been called, who's the actual person who looked at John O'Keefe's brain. So I was playing this from trial 1, and then Scordy Bellows' testimony from trial 1, and that was shown to the public from trial 1. So no, that's definitely not Welcher who's written those things on. That's Scordy Bellows. There's the L and the R. There. Okay. All right.
R, because I've never seen this green highlighting before, and it could also be Dr. Scordy Bellows. That's another possibility.
It is. It definitely is. It's from the autopsy report. It definitely is.
Not sure, but let's assume sort of the most conservative part that it's Dr. Scordy Bellows. The key part is he's got it in there and he is referencing it. So, Your Honor, the last point really for both of them, and I wanted to save this point because it applies to both. With regard to experts, the law is clear. So I think the easiest part to show what our position here is the adoption. But in it, it's clearly shown. Adoption doesn't mean you have to agree with it. You just have to put your expert hands around it, wrestle with it, deal with it. And there is no rule of law that I'm aware of that says you can't question an expert witness unless it's something that the expert witness agrees with. If the expert witness has reviewed it and considered it, and especially if they've rejected it. The easiest is obviously reviewed, considered, and adopted. But it's certainly permissible and important to a defendant's constitutional right, Sixth Amendment to cross-examination, if an expert says or even infers, I reject this, I reject what Trooper Paul did, or I reject what Dr. Scorti-Bello did, that is decision-making of an expert that the attorney has a right to be able to test. Why did you reject it? What was your thought process in rejecting it? And that applies.
Exactly. There's nothing that should preclude Alessi from questioning Welcher on these points. I don't understand. I just don't understand.
To both Trooper Paul and Dr. Scorti-Bello, because as I understand it, this witness, Dr. Welcher, is not, he says, I'm not relying upon Trooper Paul, which is completely false based upon what I just showed. But even if he just rejects it, in addition to what he has done, we have the right to test and get answers as to why he did it. And the same with Dr. Scorti-Bello. Once he goes to this level, Your Honor, I believe it's a straightforward right, especially of a defendant in a criminal trial, and especially of the stakes and the charges this high, that we get to test it. What I think, lastly, my point here, Your Honor, the Commonwealth is doing is this. The Commonwealth knows Trooper Paul and Dr. Scorti-Bello are problematic for their theory and their narrative. Trooper Paul has got, if you work backwards from his key cycles, you end up with 1162-2, their key cycle. That ends up being not in front of 34 Fairview, but it ends up when the Lexus is in the possession of the state. That is the result of that. And that was something that was addressed square head on in the first proceeding. We're not coming up with some fanciful ghost in the second trial. This was gone through extensively in the first proceeding. And I understand this is a new trial, but it goes to show it's not something coming out of the blue, etc. And with regard to Dr. Scorti-Bello, it was remarkable on the redirect that I've never seen a prosecution essentially go after the opinions and conclusion of their own medical examiner when they basically said, the medical examiner, I can't call this a homicide. The manner of death is undetermined. And the medical examiner says, I don't see any motor vehicle impact injuries. There couldn't be anything more apt, more probative than whether or not the injuries to the decedent are from a motor vehicle. The Dr. Welcher himself is saying they are. That's the essence of his opinion. It's the essence of his test. We get to be able to, respectfully, Your Honor, say, well, wait a minute. You said you looked at the autopsy. You said this. You highlight it. But you're going against the medical examiner on whether there's motor vehicle injuries. The experts can't, Your Honor, cherry pick and choose from documents. They can't use it as a shield and a sword. They can't put up, for example, Dr. Scorti-Bello's autopsy report, cherry pick things to benefit from them, and then and they did it on direct. And then all of a sudden on cross, when we want to go and test that, they say, oh, no, you can't do it. Your Honor, this whole argument is absurd. And it's antithetical to the Sixth Amendment. And even if, and this is my last point, even if this were merely a civil case, this would be routine cross-examination against the expert on the side. So in conclusion, Your Honor, I respectfully request that Ms. Reed and her team be allowed to exercise their constitutional right to cross-examination, the keystone of a defense in a criminal trial, cross-examination, and that they be able to take the shield that the prosecution is trying to put on us and be able to combat the sword that the prosecution has put forward with regard to trying to cherry pick from this information, and that we get to proceed, and we get to proceed undaunted from all the serial objections yesterday that interrupted my cross-examination. Thank you, Your Honor.
Well, she didn't agree. She said no. And I thought that was, I thought it was a no-brainer. I thought it absolutely is something that he should have been allowed to cross-examine. It was in his report. He discussed it. I don't. And she just said, I don't agree with you. And that's that. Don't agree with you. No reason. Just don't agree. Just don't agree. All right, let's go all the ways to the end because I just can't with Welcher. And let's go to the very last, you know, the final thing that the jury are going to hear from the prosecution. Yeah, denied. Just denied. That's it. Denied. Denied without hearing. Well, at least you heard them. That's one up on goal. At least you heard them. Dear God. Dear God. All right. So this is the thing that the jury is going to take away from the prosecution's case. Obviously, the prosecution comes back and does rebuttal after the defense case. So they'll be putting on more witnesses. I think the dog bite expert is going to be coming in the rebuttal case. So it's not the very last thing that the jury hears, but this is the last thing that they heard from the case in chief, at least.
So I thought, could I run him over? Did he try to get me as I was leaving and I didn't know it? I mean, I've always got the music blasting. It's snowing. I got the wipers going, the heater blasting. Did he come and hit the back of my car and I hit him in the knee and he's drunk and passed out and asphyxiated or something? And then when I hired David Yannetti, I asked him those questions the night of January 29th. Like, David, what if, I don't know, what if I ran his foot over or what if I clipped him in the knee and he passed out and or went to care for himself and he threw up or passed out? And David said, yeah, then you have some element of culpability.
So the 207?
Your Honor, the Commonwealth rests.
Okay.
Thank God for that. Look, how do you think the prosecution's case has gone? How do you think the prosecution's case has gone? I think that some elements of it were better than trial one. I definitely think it was more streamlined. There was less repetition. You know, Lally's case last year, you know, it was the same questions. Like literally everybody who was in the waterfall bar got asked the same questions. Everybody got asked if it was snowing. It was just really, really repetitive. So for that reason, I think Hank has done better. But in some ways, I think his case is worse than Lally's. At least with Lally's, by the end of the prosecution's case in chief, the jury could have no misunderstanding about what the case was about. Whereas with Brennan, because he streamlined it so much, I don't think there's a logical flow. If I was a juror, I'd be left with a lot of questions. There's a lot of gaping holes. I'd be wanting to know more about pretty much everything that's been discussed. And I certainly don't think it's been proven that there was a motor vehicle collision. I only think that I think they've what Hank's tried to do is say, well, there could be no other way for the tail light to get broken than her hitting John O'Keefe, because Welcher's fancy laser scanning and overlaying and 3D models and blah, 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 blah proves that Karen's taillight didn't break when she bumped John O'Keefe's car at One Meadows. Therefore, if the taillight's broken, it had to be done when John O'Keefe rubbed his arm on the taillight. And that stupid test with the blue paint proves it. That this is how it was done. But it doesn't. I can't. If I was a juror who knew absolutely nothing about this case, I couldn't take away that there was actually a motor vehicle collision. I think I would have questions about the people in the house. Who were they? Like, they're just completely mysterious. And I have questions about the investigation that just seem to be left hanging. And I have massive questions about the timeline. So, as a juror, I think I go away quite confused. However, I'm still not confident that there's going to be a good outcome, because Karen has been her own worst enemy. And I'll say that, and I'll say that until I'm blue in the face. She's been absolutely her own worst enemy by doing those media interviews, because Hank has been able to use them as quote-unquote confessions, like drip feeding the jury these little clips that are all out of context, but that doesn't matter. And Hank has been given this blank check to get a conviction at all costs. So he's played dirty, and Karen has been her own worst enemy. Her own worst enemy. So I don't know. I'm going to do a quick poll. Let me do a quick poll. All right. How well did the prosecution present the case? All right. Really well. Okay. Poor. Or absolutely terrible. All right, we'll run that for a few minutes. See how you feel. I think in some ways it was better, but I think in the ways that count, it was worse. But I'm not confident that we're going to see an acquittal. I think Karen could well be going to prison. Not necessarily for murder, but quite possibly for manslaughter. I certainly don't think they've proven a murder. That if she did hit him, that if the jury can conclude that she hit him, that she did it intentionally. I don't think they've even addressed that. I don't see how they've addressed that, other than, oh, there was an argument. They had an argument during, in the text messages. But there should be. If you've got questions, if you've got as many questions as I would have, then there's your reasonable doubt right there. And that should be an acquittal. But after what went down in the Delphi case, I'm just not confident. I'm not very confident with the judicial system at all, quite frankly. I'm really not confident. I think Karen could well be going to prison. And then, obviously, there might be grounds for appeal, but she's still going to prison. Yeah, well, she was walking reasonable doubt. He was. He absolutely was. Because he did not show what the way that he was billed as this star witness. He just sounded like he was the crash test dummy. He literally was the crash test dummy with blue paint on the taillight. He literally was a crash test dummy, rubbing his arm along a taillight with grease paint on it. I mean, it was just absolutely pitiful. Pitiful. If that's what an engineer calls an experiment, then engineering's got some serious problems as a as a field of study. But I'm sure that engineering, generally the engineering community don't want to own Dr. Welcher right now. But I don't know. All right, so we're going to get the defense case today. Let's think about the defense case. Right, if I was the defense, I would want to call. I would definitely want Brian Albert because of Chloe. I might only use Brian Albert in a limited fashion. I'd show him the waterfall bar stuff and the obvious disagreement that was going on between Higgins and John. Not that John necessarily knew much. John was paying the bill at the bar, but Higgins was like gesticulating and pointing and just, Chris Albert tried to calm him down. So I'd call Brian Albert for that reason and to talk about Chloe, because in trial 1, Brian Albert said that when they got home from the waterfall, he took Chloe downstairs and let her out in the backyard. And that would then be my lead in to Chloe. And I'd have 2 strands. I'd attack the case on 2 strands. One, the injuries. And I would be wanting to show that the right arm was a dog bite and dog scratches rather than injuries from a taillight. And I'd want to stress the fact that John could have fallen, because that's what the Commonwealth's own witness, Dr. Wolf, the brain guy, the head guy, said that he'd seen loads of people who are drunk and fall over. So I'd be using the drunk and fall over. We know that John's blood alcohol level was 0.2. So he was quite drunk, not blind drunk, but he was quite drunk. So I'd be wanting to get across that he could have just got drunk and fallen over. So he got drunk, fallen over, and Chloe bit him. You don't have to implicate anyone. You don't have to say anyone attacked him. You can bill it all as just a dreadful accident, and people panicked. So I'd call Brian Albert. I'd definitely call Brian Higgins because he's got the fun factor. He's the fun factor. But I definitely give Brian Higgins a hard time. I would call Nicole Albert, Brian Albert's wife, for limited purpose. 1, Chloe, and 2, well, actually 3 reasons, so not that limited. So 1, Chloe. 2, she was there, like by the side of Brian, when Brian Higgins was kicking off. So I just want to get her perspective on that. And most importantly, though, the 507 phone call between her and Jen McCabe. I'd want to know all about that. You see, it's not, she's going to deny it all. She's going to say, no, there was no phone call, no phone call, no phone. She's going to deny it all, but it brings it all back. It brings it all back to the jury's attention. It tells the story. Like I'd be telling the story through these witnesses. Who else would I call? I don't think I'd call Trooper Paul. I don't think I called Trooper Paul. I don't see any reason why Trooper Paul. Proctor, I don't even know about Proctor. I don't even know about Proctor. Also, Brian Albert said that Colin was in the house. Yes, he did. Yes, he did. He absolutely did. I don't think they need Colin. I don't think they even need to bring up Colin. I mean, they're not allowed to bring up Colin anyway. Like, they've been banned from talking about Colin. So I'd focus on Higgins. I'd focus on Higgins. I'd put it in the jury's mind that Higgins had motive, not to kill John. Like, I don't think anybody wanted to kill John, but he had a motive to maybe confront John. So in my getting it in as many times as I could that John slipped and fell, and that's how he got his brain injury, you could be planting that it was a complete and total accident, or you could say it was a confrontation that should have been relatively harmless. However, it ended tragically, and somebody made a bad decision. Also, Higgins's behaviour after, and of course, and I almost forgot, the dodgy behaviour of both Brian Albert and Brian Higgins getting rid of their phones the day before a preservation order was going to come into effect. So I'd want to know all about that. You need Proctor for the taillight pieces, lack of chain of evidence, and the edited Sallyport video. That's true. That's true. That is true. So, yeah, you're right. I would call Proctor. Unless there's another witness that you could get all that in from. But I don't know. I might, I'd call Proctor. I'd basically run an entire case. I know that the defence doesn't have to call any witnesses. The defence doesn't have to do anything. The total burden is on the Commonwealth. However, jurors don't think like that. Jurors do not think like that. I'd run a full case. It may not require quite as many witnesses as the prosecution put on, but I'd run an entire case. So that would be my first strand. So you'd have the dog bite person. What's her name? I can't remember her name. You have the dog bite person. There's 2 dog bite people, actually, this year. There's the woman who testified last year, and there's Garrett Wing, who is I'll show you his YouTube channel. You might have seen him on Melanie Little's channel. He did an interview with Melanie Little quite a while ago now, but he does have a YouTube channel, American Standard Dog Training. Here he is. 1 second. This is Garrett Wing's dog channel. 1.5 video, 2.3 million subscribers. Check that out. So this is Garrett Wing. So he's on the witness list. So look at his description. American Standard Canine offers world-class dog training backed by over 20 years of experience training police dogs for both the street and competition. Our real-world experience allows us to deliver proven practical results for dog owners, regardless of your dog's age, breed, or behavioural history. They should have employed him to deal with Chloe. Then they wouldn't have had to rehome her. I mean, that's insane. The fact that they rehomed the dog after 7 years. And also, Brian Albert. I watched Brian Albert's testimony yesterday. Criminality. Some of you will know Criminality, Teresa. She played Brian Albert's testimony yesterday. And I listened to it. And he made very sure to keep correcting saying that Chloe was a German Shepherd mix. So she wasn't just a full-on German Shepherd, she was a German Shepherd mix. I don't know whether that made a difference, but clearly Brian Albert thought it made a difference. Through our what does that say? DNK9 online courses and training videos, we give you the tools and step-by-step guidance to train your dog or puppy at home to be the best they can be. From foundational obedience to leash manners to solving common behavioral issues, our easy-to-follow programs are designed to help you build a calm, obedient, and well-balanced companion. Whether you're starting with a new puppy or looking to correct long-standing issues, are you listening, Tilly? K9 gives you access to professional level training that works in real homes with real dogs. All right. Oh, that's DIY, not DN. You see, I need glasses. DIY K9. All right, I need glasses. So, Garrett Wing. I've watched a few of his videos. He's not really my style of trainer, honestly. But anyway, that's who Garrett Wing is. So he's on the witness list. So I definitely call him. The other one. Dr. Russell. Dr. Russell, that's it. Dr. Russell. All right. So that's one strand. The second strand would be attacking the timeline because the Commonwealth's timeline does not make sense. So it would be attacking the timeline, and that would be through the phone data. So I'd have my phone experts on. And then, of course, there's ARCA. There's ARCA. And I think ARCA should have a much bigger role this year than last year. I think they should broaden the scope. Obviously within the realms of what Bev will allow, but they can get in quite a lot through ARCA, I think. And I'd use ARCA. I might not bring them on together. You know, like last year there was Dr. Wolf and then Dr. Rentschler. I might bring them on separate. I don't know. But yes, two strands, injuries, timeline, and ARCA would be the linchpin that I'd probably use more broadly. Defence needs to bring ARCA on ASAP while Rachel's testimony is fresh. Yeah, I do agree with you, actually. Like, normally they leave the best to last, like they want the recent, it's called the recency effect in psychology. So you've got the primacy effect, so that you remember the first stuff, and the recency effect, you remember the last stuff. So you either bring your best on first or your best on last. And usually in trials, they bring the best, like the most forceful, the most impactful last, for the recency effect. I get that, and that's what how Hank's done it. Fallen completely flat, in my opinion, for Hank, with Shannon Burgess and now Judson Welcher, the crash test dummy. It's fallen somewhat flat, but I think he's got away with it because he's had help from the judge. He's got away with it, I think. But with ARCA, you see, they might want that little bit of extra time to work on countering Welcher, you know, because Hank is going to be all hot in the cross-examination, and they will be aware of how hot Hank will be because he's a defence lawyer. Hank's a defence lawyer, isn't he? So he knows how to cross-examine. He knows how to do a good job of cross-examining. So ARCA might want that little bit of extra time to really firm up their report. But no, I'd bring ARCA on probably. Maybe one of them. Maybe I bring one of them first, or very early, and then maybe one of them at the end. I'd maybe bookend them like that. What do I know? I'm not a defense lawyer. I'm not a lawyer. What do I know? The defense will have Arca right out of the gate, probably tomorrow. It's Saturday tomorrow. Saturday tomorrow. Disorder. So that's the data person, isn't it? Don't know who he is. Not seen him. All right, let's see how this poll's going. Let's see how this poll's going. All right, interesting. Interesting. So we got 74 votes. 5% thinks the prosecution presented their case really well. 26% okay. 26% okay. 36% poor. And 32 absolutely terrible. Let's end that. To be honest, I think probably most people who watch my Karen Reid stuff believe that Karen's innocent. So there's a bit of maybe a bit of a bias, maybe a bit of bias in the results. But I don't think it was absolutely terrible. I don't think it was terrible. I think, you know, he's obviously planned it. He got some good points in. But I don't think it was good. I don't think it was okay. I'd have gone with poor. I think I'd have gone with poor. But look, having said that, it can only work with what's available, and because the investigation was terrible, you know, he's done well with what he's been able to use, and he's done well at whitewashing over some of the really terrible stuff, like Proctor. He's basically just whitewashed the entire case. He's just painted over. It's like what I do when I decorate. I just paint over stuff. You know, once you paint it over it, it doesn't exist. That's what he's done. But in doing that, he's left holes. In doing that, which he might have felt is necessity, quite frankly, it probably was. He's left gaping holes, and I'm not sure the jury are going to be able to understand some of the nuance because there's just not enough detail. Like I said, if I was a juror who knew nothing about the case, remember they're only allowed to see it once. We can play it back. You know, if there's something we don't understand, we can play it back, or we can go and listen to somebody talking about it to, you know, get our head around it. They can't, or at least they shouldn't. They're listening to it once, and that's it. They're listening to it once until they get in the deliberation room, and then, you know, it's weeks stuff that happened weeks ago. They've now got to bring up and try to recall. So it's very difficult, especially when it's a long trial. And it does concern me that because some of this stuff was difficult to understand, and because there's so many holes, that they might just do their own bit of airbrushing and think, well, she must be guilty. You know, this expert says she's guilty. He's cleverer than I am, therefore she must be guilty. And I hope there's not too many of that kind of person on the jury, or else Karen is in big trouble. She really is. She's in big trouble. But I've got a lot of faith in this team. I've got a lot of faith in you know, there's a lot of brains. There's a lot of brains on Karen's side, including Karen herself. You know, did you see her yesterday? Like pointing, you know, she was standing up. She was basically acting like a lawyer. She was standing up. She's pointing stuff out in the reports to Alessi. So Karen is very much involved, and she's clever. She's clever. She really is. She's been her own worst enemy, but she is clever. Like academically, she's very clever. So essentially, you know, Look at all the brains they've got. You've got Yannetti, he's a great lawyer. You've got Alan Jackson, fantastic. Great, great speaker. I just like his style. And then you've got Alessi, who is like very careful, very pragmatic. I think he probably could come across as being too complicated to jurors who are already lost. So that's an issue. And then you've got Karen, who's basically directing them all. So I've got a lot of faith in the team. However, what I don't have faith in are humans generally. I don't have faith in humans generally. So you can never predict how a jury is going to react. She was passing notes to Alessi. She was. She really was. She didn't leave with her attorneys yesterday. Yeah, she left on her own. Maybe she had an appointment. Maybe she had somewhere to be. A doctor's appointment or something. Don't know. But really good team. Really, really good team. And I think they'll pull out all the stops. I think they'll do the damnedest to get a good result. All right, I'm just waffling now. So, yeah, I'm going to call it. I'm so tired. I've not slept very well the last couple of nights, and for no reason. There's no reason. I just kept waking up. But I'm really tired. I think tomorrow I'm going to have a day off true crime. I'm going to have a tired day off true crime. I think I might do a fun members live. If anybody fancies that over on Michelle After Dark. I just feel that I need a little bit of a break and just to do something different. So unless there's any breaking news in any of the cases that I'm following, and then obviously I'll be there. But if there's no breaking news, I think I'm going to have a really easy day tomorrow. I think I'm going to have loads of naps and do a fun members live. I think that will be the way to go tomorrow. I think so. All right. So in another hour and a little bit, we will have what day are we on even? Day 24, is it? Is day 25? 24, 25. I think it's day 24. And the beginning of the defense case. The beginning of the defense case. And it will be a good one. It will be a good one. I'm confident. I've got confidence in them. All right, guys. Thank you for joining me. As always, I won't be back tomorrow to do a recap. As I've just said, I'm trying to have a whole day off. Off true crime, unless there's breaking news. So I'll either do the trial recap of today on Sunday or Monday morning. So there you go. All right, guys. Thanks for joining me. Thanks, as always, to the mods. It's gone suddenly very dark. There was like big black clouds over this morning, and it just drizzled a little bit, and then they went over, and it was sunny. And I put some of my plants outside, some of my succulents outside to soak up the sun. And now it's gone really dark again, so I might have to bring them straight in. All right, I'm gone. Enjoy the rest of your day. Oh, Jack and Lily video just about to be released over on Michelle After Dark for anybody following that case, because it's already uploaded. I just haven't made it live. All right. Bye, guys. See you soon.